This episode is brought to you by Microsoft Azure. Turn your ideas into reality with an Azure free account. Get everything you need to develop apps across cloud and hybrid environments, scale workloads, create cloud-connected mobile experiences, and so much more. Discover what you can create with popular services free for 12 months. Learn more at azure.com. That's AZURE.com. And sign up for a free account to start building in the cloud today.
What are loan-out companies? They're also known as personal service companies, PSC, and they are from the United States of America, the first biggest country for the entertainment industry in the world. The idea, the main idea is that the talent loans out his or her services via a corporate body to his or her end clients. Okay, so the creator, the talent, provides the services, but the services are actually provided through a legal entity, which is the loan-out company, hence the name loan-out company. And as I said, in the UK, HMRC, which is the taxman in the UK, of course, usually refers to this type of companies as personal service companies, PSCs. The way a PSC or a loan-out company is usually structured is that it has a sole shareholder, which is the talent, the individual who will provide the services. So he or she is the sole shareholder most of the time. Also, quite often, this individual is the sole director of the PSC, of a loan-out company. So how does the contractual relationship work between the loan-out company, the talent, and the end client? Well, in a loan-out structure, the contract loan-out agreement is entered into between the PSC, the loan-out company, and the end client. And as a subject, as the main purpose of this loan-out agreement is actually the provision, the execution of those services, which is going to be done by the talent, by the creator, by the individual. This loan-out structure is a good fit for the entertainment and media and sports industry because the talent in these sectors receive some sums of money sporadically for the provision of their services, usually in big chunks, in a big one front sum, and then nothing for 3 or 4 months, for example, and then another contract comes in, etc., etc. So it's a good fit for, in particular, the entertainment industry, although I have also seen some loan-out structures being used even in the public sector. We'll come back to this in a bit, but for consultancy roles, etc. Where does the loan-out structure come from, from a legal standpoint? We know that it's originated in the US back in the 30s, but where is it coming from a legal standpoint? Well, it's actually Article 17 of the OECD Model Income Tax Treaty dated 1930, which put in place this idea of a loan-out. Why? Because back then, entertainers were traveling, to go to gigs or to go to live events, to perform their services live. They were traveling all around the world, and therefore they were generating various income streams from different countries around the world. And so the question came out as to where are we going to tax these entertainers in the world? Should we tax them in each country individually, or how do we do this? And so this Article 17 of the OECD Model Income Tax Treaty from 1930, so it's a long time ago, basically provided for the fact that all these income streams of this entertainer should solely be taxed in the country in which the entertainer is a tax resident. Once this Article 17 was entered into force through this OECD tax treaty in 1930, that was a foundation, the legal foundation on which those loan-out companies, loan-out corporations were structured. Okay, so basically what the entertainer would do is that he or she would set up this legal entity in his or her tax resident country and make sure that all the monies, all the payments were funneled to this loan out company in the country of his or her residence. And then every year, he or she would go to see his or her accountant, and they would do the tax thing, and they would pay the tax payment on income tax and if applicable, NIC's, national insurance contributions. So in the 1970s and the 1980s, this model of the loan out structure really picked. I mean, it really became very widely used in the UK, which adopted the model, as you can see, pretty fairly early from the US. As far as I know, the loan out company doesn't really exist in continental Europe, in particular France. This is not really a structure that exists. Okay, so it's pretty an Anglo-Saxon thing, and definitely works in the UK for sure. So this is the end of the first section, and I'm going to check on various devices, whether platforms, whether you guys have got any questions or any comments. Okay, so we have Sarah, who is asking how to set up a loan out company. So it's very easy, Sarah. In the UK, there is the Register of Companies, which is called the Companies House, and you just need to set up a normal standard private company limited by shares with Companies House, and call it a personal service company while you are declaring it to the registrar, to Companies House. Moreover, in the bylaws of this new company that you are, this private company limited by shares that you have incorporated, well, you are not going to take the default model bylaws, but you are going to customize them, those bylaws, so in order to make sure that the object and the purpose of this new company is actually to basically be to manage your personal services, or the personal services of a sole shareholder and director. And that's it. That's how you set up a personal service company, or otherwise called a loan out company. How do you use loan out companies? How entertainers and the talent and professional sports people do use loan out companies? Well, as I explained before, it became a fairly successful and widely used structure back in the 1970s and 1980s. Why? Well, firstly, because it protects the personal liability and the personal assets of the talent. Why? Because contractually, as I explained, the only two entities which enter into a contractual relationship in the loan out agreement are the personal service company, the loan out company, and the end customer. So this end customer could be Warner, or the other major in the music business, Universal, Sony. It could be a broadcaster like the BBC, like Sky, etc. So that is the type of end clients we're talking about. And if we are talking about a professional sports person, it could be also some brands who want to do deals with sports stars, and they want to do some endorsing deals. Okay, these brands. As I said, contractually, in case the services are not executed, the only contractual recourse that the end client has is against the personal service company. It cannot go after the natural person, i.e. the talent, the creator, or the sports person, etc. And the other advantage of a loan out structure is that it protects the personal assets of the talent, because under English corporate law, under UK corporate law, the personal liability of a shareholder is limited to the sum of money that he or she has spent buying the shares. So say, for example, you've got a shareholding capital of £5,000. Well, the personal liability of a sole shareholder of his company, which has a shareholding capital of £5,000, will be £5,000 on his or her personal assets. and any creditor cannot go after this natural person, after this shareholder, for more than £5,000. So that's pretty cool, because it means that you hedge your bets here. Your risks are seriously limited and hedged as a talent. I'm sure you've heard that under UK corporate law, a director might be in certain circumstances liable because of his or her actions, in particular, gross negligence or et cetera, while managing the company. However, in the United Kingdom, the corporate veil principle is quite thick. Corporate veil is an expression which you cannot go after the people who are either managing or owning the business, the company. Okay, it's very difficult. The corporate veil is that basically there's a veil, which means that you only have a fronting entity, which is this corporation, and you cannot go beyond this veil created by this corporation by going after the shareholders, by going after the directors, et cetera. And while, again, in continental Europe, such as France, for example, it is very easy. I mean, it's much easier to actually go after the personal assets of a director who has committed fraud or has done some very disputable acts. In the United Kingdom, this corporate veil is really quite thick. It's very difficult to actually prove the personal liability of a director in front of in UK courts, which would trigger his or her liability on his or her personal assets. So thanks to that, the fact that the liability of shareholders is limited to the shareholding capital of a UK company, as I'm sure you know, most UK companies have a very low share capital. I mean, if you look at companies' house registers, you will see a lot of companies have a shareholding capital of £100, £200, £300, nothing. I'm saying nothing because compared to France, for example, you cannot decently have a shareholding capital which is less than €1,000. Nobody would take you seriously if your shareholding capital is less than 1,000 or 5,000 euros. In the UK, it doesn't matter. I've seen some very, very thriving, in particular, fashion businesses, making several millions of pounds per year in turnover, who had a shareholding capital of £500. So yeah, and so through that, the liability of shareholders limited to the shareholding capital, and the thick corporate veil, which applies in the United Kingdom, the personal assets of a talent and his or her personal liability are protected, almost always intact. Another advantage of the loan-out company structure is that the loan-out company, the personal service company, is going to be responsible for paying the tax, the income tax payments to HMRC, the UK taxman, as well as, if applicable, some national insurance contributions, NICs. The end client usually does not deal with this part of managing the business of a talent. The end client, in a normal loan-out structure, only pays the gross sum of money to the personal service company of a talent, and then it's actually that loan-out company, this personal service company, which will have the accountant of the PSC do all the tax things, of the tax payments and assessments. That's good for the end client, obviously, the brand or the broadcaster or the sports team, because he doesn't have to provide any of these additional payments of tax and NICs while making the payment. And also, this end client is happy with the loan-out structure because it doesn't have to deal with all the complications that one might have with an employee, such as complying with working time regulations and paid holiday regulations and other stuff like harassment policy and all these usual employment law boilerplates and regulations that are in place for UK employees and people who are earning a salary rather than a loan-out payment. It also has, this loan-out structure, some advantages, in particular tax advantages and financial advantages for the talent, for the creator. Why? Well, firstly, because the PSC structure is advantages from a tax standpoint because you can deduct way more expenses from your earnings than if you were an employee, someone who receives a salary under UK tax law. For example, some expenses due to wining and dining a client that could be deducted against your earnings, the PSC, or if you have to pay for some traveling costs and the accommodation costs, that could be also deducted. So it's tax efficient, this PSC and loan-out model, because you can deduct a lot of stuff from your earnings, from your turnover, and therefore it means that at the end, the net amount is lower on which you will have to pay some income tax. So that's good. And the second advantage for the talent, for the creator of a loan-out structure, is that it's good to manage your cash flow. As I mentioned before, PSC is often used by an entertainer, a talent, because it's a good fit with the payment model of an entertainer, which is that he or she gets big chunks of money once every, 1-2 months or every quarter, etc., etc. So when you only have to pay the income tax and potentially some NICs, if applicable, once a year, I think usually in September time, because the HMRC asks you to do your self-assessment tax form, then it means that you can actually save some cash, put it on a savings account or in reserves for 2 or 3 quarters before you actually have to transfer this cash to the taxman to pay all your income taxes and any other charges on the payment you receive from your contracts with end clients. And the further advantage of a loan-out structure is that you get paid dividends, right? Basically, in the UK, the only 2 ways that I know, legal ways that I know, that some money can be paid to a director and shareholder is through either a salary, as if this person is an employee, or for dividends, dividends on your shares, right? And as I mentioned before, the talent is the sole shareholder. From what I've seen, it's always the sole shareholder of this loan-out company, this PSC. So therefore, it's more tax efficient, so to speak, for the PSC to actually transfer some dividend payments to the individual, to the talent, as opposed to paying him or her a salary. For example, on dividends, you don't have to pay the national insurance contributions. So these are the 3 reasons for which the talent really likes the loan-out structure from a finance and tax standpoint. It seems to be quite a win-win situation for creators, for the talent, and for the end clients. So, for example, in the film industry, the loan-out structure is very often used for above-the-line casts, such as directors, actors, of course, the talent, and also producers. So usually, and top crew as well on films. They usually have their own loan-out structure in place. As I said before, also in the sports industry, entertainment industry, etc. The legal practitioners have actually really developed their skills and have developed a good skill set to provide some template loan-out agreements to their clients very quickly. So the way it's usually structured in the UK, this loan-out structure, once you've set up your PSC, your personal service company, is that the talent, who his or her agent, are going to agree the commercial terms with the end client. For example, how much is going to be paid for the provision of the services, when are the services going to be provided, and for how long, and what services are going to be provided. So all these basic terms are going to be defined usually through exchange by emails or phone call or a video conference or person-to-person conference. And then the second stage, once all those commercial terms have been agreed, is to actually enter a certificate of engagement, a COE, certificate of engagement, which is like a 1 or 2 page agreement on which the main terms are set out. So this is going to be ironed out, this is going to be signed, and it's even possible that the parties are from then going to actually start working on the project. But in the background, the lawyers, the solicitors are still going to work to actually draft a long-form agreement, which is going to be called either a producer agreement or a modeling agreement or a loan-out agreement. Some of them can actually be called loan-out agreements. And in these long-form agreements, long-form loan-out agreements, this is where the nitty-gritty of the legal provisions are going to be set out. And in particular, one thing that really needs to be taken into consideration for the production company, so the end client, so the production company or the brand, or so the end client, needs to make sure that there are some appropriate provisions in the loan out agreement so that all the intellectual property and all the services provided by the talent via this personal service company are going to be transferred to the production company. So let me give you an example. You take a top DOP, director of photography, to shoot the next Wes Anderson movie. It's going to be shot in the UK. This DOP, director of photography, has a loan out company set up in the UK. In the long-term agreement, the loan out agreement, which is going to be drafted after the COE has been signed, it needs to set out a clause which will transfer permanently, through an assignment of rights, all the intellectual property that this DOP, this director of photography, is going to create through his or her participation into the making of the next Wes Anderson feature film. This creation is going to be protected by copyright, which is one of the intellectual property rights which exist. And that copyright, created by the DOP while providing those services, will be transferred permanently to the production company Wes Anderson via an assignment of intellectual property rights of copyright. And that assignment of copyright and other rights relating to the creation by the DOP will be governed by this long form agreement, which is called the loan out agreement. Well, it could, in this particular instance, it could be called a director of photography agreement. Recently, actually, our law firm Crifovi has reviewed a producer's agreement, which was sent to us by a producer on a 4 episodes BBC series. So the BBC being the commissioning broadcaster of a production company. Okay, and that production company wanted to basically use the services of our client, who is a producer, film producer, to work on this new series for the BBC. And so this long form agreement was called a producer agreement. And we actually reviewed, us at Crifovi, our law firm Crifovi, the loan out agreement, the draft loan out agreement, while the producer was already very much in pre-production mode, working on the creation of his BBC series every day. So as I said, sometimes the solicitors and lawyers have to catch up, the fact that the parties have already started working together, and the talent is already providing the services to the end client, in this case, the film production company, because timing issues and stuff. Just a last point on this about the transfer of intellectual property in particular, and other also essential clauses that need to be included in the long form agreement. Our recommendation at Crifovi is to always get some expert legal advice from an entertainment lawyer qualified under English law before you enter into an English law governed loan out agreement. Sebastian is asking, can you use a loan out structure other sectors than entertainment, such as, for example, the public sector? Yes, and I'm going to come to this in a second, actually, Sebastian, because there's a very pertinent case that happened in the UK, and not only one, but several cases which happened in the UK, and which actually triggered the IR35 rules. So what is the future of loan out companies in the new legal framework created by the change in the IR35 rules? When I mentioned before, a loan out agreement via an SPC was a win-win situation, that's true for the talent as well as the end customer, the end client. But that's not true for HMRC, the taxman in the UK. Why? Because as I explained, HMRC misses on, for example, some national insurance contributions that could be paid in case those payments made to the talent were qualified as salaries. So what happened in the late 1990s is that some concerns were raised that PSCs, loan out companies in the UK, were used to avoid the tax and national insurance contributions, while in practice, the contractual relationships between the talent and the end customer was an employee to employer relationship. The talent had a right to holiday. The talent was not working more than 48 hours per week, in the same way that it is required under the working time regulations. So de facto, the contractual relationship between the talent and the end client was actually that of an employee to an employer. On paper, it was deemed to be a loan-out type of relationship. During the March 1999 budget, the Labour government decided to tighten the rules relating to personal service companies, which is the legal term under which loan-out companies are referred to by HMRC. So personal service company is the tax term and the legal term which is used by HMRC and also the UK government to refer to these loan-out companies. And in the March 99 budget, the Labour government decided to tighten the screw. Therefore, some provisions were added in the Finance Act 2000 with effect for 2000-2001 tax year. Those regulations were actually called IR35. Why? Because this was the number under which they were added in the budget press notice, IR35. And that term stick. And since we refer to these rules regulating personal service companies, also called loan-out companies, as IR35. How did the Labour government tighten the screw? Initially, the idea was that the end customer would be responsible for assessing whether the payment made to the talent had to be subjected to tax and NIC's payments, as opposed to the personal services company deciding whether some tax payments had to be made and NICs had to be made. It was found that this was a bit too stringent. So the first IR35 rules, which were implemented from the 2000 to 2001 tax year, were the possibility to requalify a relationship between a talent and an end consumer as an employee to employer relationship for tax purposes. So even when a loan-out agreement had been entered into by the personal service company and the end client, if it was confirmed, looking on the face of the fact that actually this talent was merely acting as an employee of this end customer, then HMRC would be able to requalify this particular working relationship as an employment contract, and therefore tax the payments made to the talent for income tax and NIC purposes. This system went on for 20 years. Surprisingly, the Conservative governments, which succeeded the Labour one, kept the IR35 rules as they were for 20 years. But then what happened is that in mid-noughties, around 2012, 2014, some scandals started to arise in the public sector in particular, because a lot of top management in the public sector, and in particular the BBC, which is the state-owned broadcaster in the UK, so a lot of top management and top talent were actually being paid through a loan-out structure, while on the face of it, they were working like an employee, 12 months a year and 5 days a week and for 48 hours, like that. So everything was as if they were an employee, but they had all the tax advantages of the loan-out structure. This was unacceptable for the government, even the Tory government. They decided to clean house. After those scandals erupted, some sweeping reforms were made to the IR35 system from 2014 onwards in the public sector. Once the public sector was cleaned out of all these loan-out structures which had no place and no reason to be, the Conservative government started to also redefine the rules for the private sector. And such reforms for the private sector of the IR35 rules came into force on the 6th of April 2021. So this year, around 4 or 5 months ago. What was the main reform of this amended version of the IR35 rules starting applying from April 2021 onwards? The onus used to be on the personal service companies to decide whether the payments received by the talent was a payment made through a loan-out structure, and therefore it was the responsibility of the loan-out company to make the payments for the NIC, if applicable, and the tax income payments. The PSCs were in charge of that before April 2021, but after April 2021, this responsibility shifted from the PSCs to the end customer. Why? Because a loan-out company is a small private company limited by shares, lost in the sea of the hundreds and thousands of private company limited by shares that exist in the UK. Bear in mind that in the United Kingdom, and probably in most of other developed countries in the world, 95% of companies in the UK are private company limited by shares, the rest being public listed companies. PSCs are usually very tiny compared to the size of the companies of very large corporates such as LVMH, the fashion conglomerate, or the three majors in the music and film industry, Warner Chappell, Warner Brothers, Universal, and Sony. So it's much easier for the HMRC, the UK taxman, to go after these behemoths of companies which have headquarters perhaps in the US, but also in the UK. And it's much easier to get to them as opposed to all these small loan-out companies and SPCs, which are difficult to track down. So as I was saying, from April 2021 onwards, the major change in the private sector is that now the end customer, so it could be also a film production company, needs to assess from the outset whether its relationship with a talent is appropriate for a loan-out structure, because it's actually a loan-out agreement. So for a limited period of time, say the talent will have to work 90 hours a week because in production time. So it's very different from an employee to employment relationship. In this particular case, then if the end customer can prove this, for example, a film production company can prove that this is real on the face of the fact, it will be a real talent / end customer company relationship, then it is fine to use the loan-out structure. And then in this case, it is still the SPC, the loan-out company, that needs to pay any tax on the payments made by the end customer to the talent. If during the prior assessment, the end customer notices that a talent will work for, say, 2 or 3 years on the project every working day, and will have to comply with the working time regulations because he or she will only work 48 hours a week. He or she will actually work from the end customer's offices as opposed to from home or from his SPC's head office. If it turns out that in the face of a fact, it's actually an employee to employer relationship, which the end customer is going to establish with the talent, then the end customer needs to take a proactive step and put this particular talent on its payroll by making sure that the payment paid to this talent will be taxed for income tax purposes, and also that some NIC's, national insurance contributions, will be paid on these payments. If this end customer doesn't do that, then HMRC will come after it further to some queries, like HMRC does from time to time, to double check that everybody's in line and in compliance with rules. And then after an investigation, if it is found that actually the talent wasn't an employee really, then there will be some tax payments to pay back to the HMRC, plus also potentially some fines if it's not the first time or if it was done in bad will, etc. That is a big responsibility for big names in the entertainment industry or in the sports industry to make sure that they comply with this rule from a reputational standpoint, but also, of course, from a financial and tax and legal standpoint. So the stakes are being raised, and it's much better for a prominent broadcaster or major company or very large independent film production company to play by the rules. There's an important criteria, though, that I have to mention, which is that only large and medium-sized projects and companies will be subjected to this new IR35 rules. Say, for example, you have a film production company, which is the end client, and this film production company is going to employ a talent for a movie which is going to be with a budget of, say, £50,000. Well, that's definitely a small budget, a small project. And therefore, in this case, then there is no need to apply with the new IR35 rules. And we had this case recently where, as I mentioned before, I was reviewing the draft loan-out agreement of a client, and the budget of this BBC series was not disclosed in the draft loan agreement. And that was the way to assess whether this was a small or a medium to large project. The project for this series was £10 million. So, of course, when you have a budget of £10 million, this is definitely a medium to large film production company, even if it's an empty shell at the beginning. It means that £10 million are going to be injected in that film production company, and therefore it is subjected to comply with the IR35 rules. And interestingly enough, the solicitor, which is quite a prominent solicitor's firm in London in the entertainment legal sphere, the solicitor had actually in its draft still placed the onus of paying the tax income and national insurance contributions on the payments made to the talent on his PSC, on his loan out company. This draft loan agreement prepared by the other side, by the customer, the independent film production company, was not compliant with the IR35 rules, which of course I mentioned to our client who was this talent, the film producer, and I said to him, you need to sort this out with your accountant, and also speaking to the end customer and making sure that they put you on the payroll to make sure that your payments are actually taxed for income tax purposes and NICs. Because for a £10 million budget, this is definitely ranking into the medium to large sized film production companies. Is there any interest to still have a personal service company or loan out company in the UK now with a new IR35 framework? I do think so. Of course, provided that there is a real loan out relationship in place between the talent and the end customer, which is much closer to being a freelancer than to being an employee. So provided that there is no subordination relationship existing between the talent and the end customer, I really do think that loan out companies are an appropriate way to structure your entertainment business, because there are some other advantages of the loan out structure, such as the one I mentioned before, cash flow management and flexibility that a loan out structure gives you, as well as the fact that you can deduct a lot of your expenses against the turnover that you make.